has currently joined us. We see people coming in, still coming in, quite a bit of folks. So we'll wait just a couple minutes and then we'll kick off to respect everyone's time very shortly.
Good evening, everyone. Really appreciate you taking some time out of your evening to join us. I want to thank my fellow team members, the staff with Housing and Community Development for hosting this and helping us do this in a format that helps get the word out and share this information. I want to quickly just share a few things before we get into the substance of the presentation. Today's purpose is to cover and provide an overview of the proposed source of income ordinance that would be added to the Human Relations Ordinance, adding this protection. I think it's important that for today, we take time to listen to your concerns, to your questions. We will do our best to answer questions as much as we can today. We may not be able to get to all the questions or even be able to answer all the questions. Our hope and plan is to compile all the information that we received today and provide that to Mayor and Council. Mayor and Council will be meeting on September 27th to consider this ordinance revision. So please use the chat or the question and answer function to submit either your questions, your general comments about this, and please know that those will be compiled into a report to Mayor and Council. We also hope and plan to do a general frequently asked questions based on the 2 public meetings we had. And so we will be notifying those who share their emails with us about when that is posted. So please know that we also will, we're going to have some of our staff, Ernesto Portillo and Allison Miller, help field the questions and ask those of Ann and I, and maybe even other city staff. So if we don't get to everyone's question, we definitely are going to try to make sure we answer at least one question from every person as much as we can. We are shooting to have this meeting at 1 hour, just to let you have your evening to yourself after this is over. So one more thing, this is a webinar. Zoom has 2 options. A regular meeting where we can see everyone and people can freely talk and do those things. What we found out is with the regular meeting, it was a limit of 100 participants. We had well over 150 sign up for today. So we are using the webinar function, which is a little different than maybe what you've done with a regular Zoom meeting. So I wanted to share that context as to why this is a bit of a different format. Before I introduce Ann Chineka, who's the Deputy Director for Housing and Community Development, I wanted to give just a few of my personal comments on this. As you know, with Mayor and Council considering this is one of many policy initiatives and action items through the Housing Affordability Strategy for Tucson, which you'll hear a little bit more from Ann as to how this came about. But you know, this was one of many tools to try to address some of the concerns and comments we are hearing from residents in Tucson who have very limited choice because of either their source of income or the rental assistance that they have. We are not making this up as a first-time measure. This is a measure that has been taken by many communities across the country in at least 30 states, over 120 jurisdictions. So this is something that is not new, but it is new in Arizona. We know this will not solve our housing crisis, but it is my hope that it will open more options and more doors for those who have the means to pay for their rent for stable housing. I do want to acknowledge and thank our landlords who have worked with our programs, our emergency rental assistance program, that between Tucson and Pima County, we've been able to disperse over $63 million. Landlords have been wonderful to work with that program to ensure people stay housed. Also, working with many of our other programs, but this has been a very tough time for our landlords through the COVID many of them did keep people housed without getting rent, and that was a very challenging time. But I also want to acknowledge our residents who have been affected so severely by rising rents and many who have had to move. This has been very, very difficult. I would even go as far as traumatic for many households in Tucson. So we appreciate you for your interest in this topic. We take this topic very seriously. We know it has many impacts. And so again, your comments, your submission is really important. We also acknowledge that the programs like Section 8 Housing Choice Voucher programs haven't always had the best reputation or have provided good service to our landlords. So we have taken a lot of steps and progress to improve our program, and we will continue to work to improve the program. So I will now ask Ann to introduce herself, and thank you, Ann, for taking on this task of sharing what the ordinance is.
Thank you, Liz, and thank you everyone for joining this evening. I know that you're all busy, and taking time out shows that you care about this topic, and we really appreciate you taking time to learn more about it. And as Liz mentioned, sharing your thoughts, asking your questions. That is what today is about. As Liz mentioned, don't hesitate. There is the chat function, and there is also the question and answer. So even while I'm talking, if you have questions, if you want to make comments in the chat, feel free to do that. As you mentioned, Ernesto and Allison will be summarizing these questions and really trying to provide us with a way to answer those questions as we're going. So they'll be grouping questions together. So as Liz mentioned, I'm a deputy director here at Housing and Community Development. One of the areas I've been overseeing is our housing affordability strategy. So really focused on how to increase the number of units so that there are more housing options, and also some of our planning efforts. And so I am going to share my screen. There is a short presentation, but most of the time today will be an opportunity to ask questions and make comments. but we wanted to provide a little more context as to what this source of income ordinance is. And so this intro slide here, really the goal is to protect Tucsonans from discrimination based on source of income. We know that mayor and council have an equity goal in terms of really advancing racial equity and really trying to support low-income residents in Tucson. And so really this is one of the strategies thinking about advancing equity and also looking at it as a housing strategy. So late last year, mayor and council adopted our housing affordability strategy for Tucson. And as Liz mentioned, there are many, many strategies and many, many initiatives that the city of Tucson has undertaken really related to housing affordability. And so that plan has 10 key strategies and then some sub-strategies laid out in the plan. And so please know that there are many different areas that the city is working on. And I really appreciate our HCD staff. People are working really hard across many different activities, trying to think about how to increase housing options for people. In the HAS plan, there is a strategy on improving access and really trying to provide more housing options. And as part of that, strategy 3.2, you can see here on the screen, mayor and council asked us to evaluate changes to the city's human relations ordinance. And really, as Liz mentioned, this is something that many other communities have done. And so we were asked to evaluate whether or not this could be done and sort of what would be the benefits of that. On the HAS plan, there's a succinct summary of what that proposed on pages 29 and 30 of the plan. And so what is our human service ordinance? This is in the Tucson code. It's section 17. There is a whole section for human services. This is the introduction paragraph, and I don't normally read PowerPoint screens, but I am going to just say this is really to eliminate discrimination due to race, color, religion, ancestry, sex, age, disability, national origin, sexual orientation, gender identity, familial status, or marital status in places of public accommodation, employment, and in housing. So this is what our code says today. And so today that ordinance is in place protecting those classes from employment and in housing. And so what is being proposed to mayor and council is adding source of income as one of those protected classes. So there is a red line version of the proposed ordinance on the website. I will go over that very briefly when I'm done with these slides. But really what's being proposed is adding source of income as one of those protected classes. And so you may be wondering, what does that mean? So in terms of this context, what we are talking about is source of income discrimination, referring to the practice of refusing to rent to a housing applicant because of that person's lawful form of income. And so I'm not going to read this whole section here, but I did want to include this whole section. This is straight from the proposed ordinance. This is how we are defining source of income. And so I did want to make sure to mention there are many sources of income that are verifiable and are lawful. And so this definition really tries to cover many of them and also recognizes that there are any program, assistance, benefit, or subsidy that's lawful and can be verified. So this includes, but is not limited to, wages, salaries, child support, rental assistance, down payment assistance, Social Security, disability insurance, veterans benefits, or any other form of governmental assistance, benefit, or subsidy, including our Housing Choice Voucher Program, or what was formerly known as Section 8. And so We keep mentioning that this is a way to advance racial equity and equity against low-income populations, discrimination against low-income populations, and a way to try to provide more housing options. And so here are a few statistics about the city's Section 8 program. This is only the city's program. This doesn't include our nonprofit partners and other folks who do operate housing. And so a few of these pieces, one challenge we've had is in the current market, what that is as hot as the current market is, really trying to retain landlords has been a challenge. So over the past year, we've had almost 100 landlords exit the program. So we have a lot of people looking for vouchers, and it's taking a really long time for people to secure housing and find housing. And so those are all areas that we're hoping to provide more options for people. And so I mentioned that this strategy was adopted in the Housing Affordability Strategy Plan that Mayor and Council adopted at the end of the year in terms of evaluating. So working with our city attorney's office, we thought through, did some research as to how this is working in other communities, and then worked with the attorney's office to draft the ordinance language. Recently, we created a website, and I'll ask if staff hasn't already to make sure there is the link to the website in the chat. So we created a website with information on the proposed ordinance. There is a spot on the website where you can take a survey. What the survey is really to provide an opportunity for anyone to voice their thoughts on the ordinance, and it's a really short survey with just a couple questions. The website also has the information on the public meetings. Today's public meeting is wrapping up the public meetings. We had an in-person one last week. And then one of the things in terms of from here and what we've heard in the last meeting and here tonight, we will be updating the website. And as Liz mentioned, updating the frequently asked questions and really making sure we reflect what we hear. And then, as Liz mentioned, at this time, we are shooting to take the ordinance to mayor and council at their second meeting in September, which is scheduled for September 27th. After I wrap up a few things, I will go to the website, but the website has different pieces of information, including where you can download the draft ordinance, either a clean version where you don't see all the red lines, or a red line version, since this really is amending the existing human service ordinance. On the website, there is currently a frequently asked questions. This is what we do plan on updating based on the feedback we've got at the last meeting and what we get today, but really trying to help understand what this ordinance would do and wouldn't do. I do think that there is some misconceptions about it, and understandably some concerns that we really hope to address with the questionnaire. So for instance, one of the questions we have received from landlords is, will I be required to lower my rent? And so the Q&A is really trying to get at what it would and wouldn't do. And the answer to that is no, landlords can set their own rent and they won't be required to lower their rent. And so there are a lot of other questions on that FAQ section of the website.
And can I jump in?
Absolutely.
Yes, I just wanted to clarify, the reason that landlords would not be required to lower rents is because we are unable to require that. So I just wanted to clarify, it's not that we don't want to, we just don't have the authority to do that.
Thank you, Liz. I appreciate it, and feel free to jump in at any point. And so one of the, in listening to so far in the outreach we've done and over since the time I've joined HCD, I did want to mention one of the concerns regarding the Section 8 program, the Housing Choice Voucher program, has been past performance. And I'll say, working with Liz, who spent a lot of her career in Section 8, I've really been amazed when she came into HCD and changes she made to really improve performance. So we had heard in the past concern about the time it took to do inspections. And so now that time is really on average 4 days in terms of doing an inspection. Another has been landlords, when they would get paid for their first payment, that had been quite a bit, it had been over 30 days. That is now down to about 15 days after the contract is executed. And then really concerned over not having enough support for landlords, and really grateful Fernando Moraga is on this call today. He heads our landlord support team. And so really looking to support him and his team being able to work with landlords and help them through the process. One other questions that we've been getting is about compliance and what that looks like should mayor and council adopt the proposed changes to the ordinance. And so we wanted to talk through that a little bit, and we're happy to answer questions. But the key thing here is we're not trying to penalize landlords. We're really trying to get compliance and really make sure that there isn't discrimination happening. And so education will be a key component of really trying to make sure that people are adhering to the ordinance. As I mentioned, the goal really is compliance. And then should there be, if people suspect that there is discrimination because of their source of income, it will go through what the current human services ordinance lays out. And so there will be a complaint. The way that the process works today, and this is a really oversimplified version of it, but just wanted to give some of the key points. If somebody suspects they were discriminated because of their source of income, they would file a complaint with our Office of Equal Opportunity, and we'll make sure that we update our website to reflect some of this. If then at that point, their investigation to see if there was if the complaint is legitimate, should it be found that there was discrimination, really the goal is getting in compliance. And so a conciliation agreement can be made in which there's no penalties. It's just this landlord would agree to not do that again, and to make sure that they fully understand what the ordinance says. And then, if there is just a blatant disregard, there is the option of going through the court system and it being a civil infraction that could result in penalties. And one thing we've been working on, we've heard that there could be improvements to the enforcement process of the current human service ordinances. So we've been meeting with the Office of Equal Opportunity and Southwest Fair Housing to really figure out how to improve, with the goal being to just prevent discrimination and increase housing options. And so I'm going to switch over quickly to the website, and then we will open it up to questions. So the website's, fairly simple at this time. There is an opening page that walks through different ways to access the proposed ordinance. There is an overview of what is source of income protection, what is currently being considered, some of the information I shared about improvements with our housing choice voucher program, information on, sorry, my computer's slow, source of income protection in other states. So what have other states and other municipalities done? There's information there. And then linking it back to our housing affordability strategy. At the top, there are different tabs. There is a way to view the ordinance on your phone where you don't have to download anything. Information on these meetings, but then also the place where you can provide and take the survey. And then last, the frequently asked questions section that we talked about. So At this point, I'm going to turn it back over to Liz for Q&A, and we have a few folks here to help answer those questions.
Liz, this is Ernesto. One of the questions in the Q&A one of the participants asks, tenants who look for Section 8 will ask a property manager, do you accept Section 8? The question is, since the property manager doesn't have any Section 8 units, does this mean we are going to qualify all rentals to accept Section 8?
So I'm actually wondering if we can have this person ask that question verbally. I'm not completely clear on that question. Can we make that person?
It's Ela Kresnik.
Yeah, Isla.
Hi, Liz. Hi, Liz.
Hello.
Hi. So good to see you again. Of course. So aside from other concerns that we've already talked with you about, I was thinking about that. That's the first question that came to my mind during this presentation. That's the first question they asked. Do you accept Section 8? Well, even if I did, I don't have any homes that are qualified. So what's your strategy on that?
So Isla, if I understand correctly, one of the things is every property manager, landlord, when you have available units, you accept applications. And so the hope with this ordinance is that you would screen all your applications as you do, regardless of other than your criteria. We always encourage landlords to have an applicant criteria. So the one thing we hope is that people who have, regardless of their income source, how they pay the rent, that they would be reviewed like other tenants. If a landlord does not have any available units, then this is based on vacancy of units and processing applications. I think landlords typically have been gracious to tell applicants up front, if you have a Section 8 voucher, we won't waste your time in having you go through the application process. But in this case, the idea is you would still have them apply and go through your criteria and then offer the unit in the order you would do. So just because someone has a rental assistance doesn't mean they get any priority or preference. They are just part of your applicant pool. Does that answer your question? I wasn't sure if
so say they qualify based on, well, you're going to pay their rent. Everything else is great, credit and all the things that we use for criteria to approve an application. So now we get to the end of that. We're at the approval process, but I don't have a house to put them in.
Right. So again, it may be you put applicants, you're processing applicants without available units. Should a unit come available and they're next in line, that could be something if it meets their criteria, again, for the program. Then you would say this we don't have a unit available until there's one available. I don't know if I'm capturing your question correctly, but
I don't make a habit, and I don't think other property managers do too, but I'll speak for myself, of collecting application fees and processing those unless I have something that they're interested in and that I've shown them.
Yeah, I would say whatever your process is today should not change as a result if this ordinance is passed. So you continue doing your process how you would do it. The question is, when you have an open vacant unit and you're looking for renters, the only difference here is, just like you would not tell someone because of their family size or that you would say you can't apply. All we're saying is you would open up your application, including people who might have some type of rental assistance.
Then we'd have to go back to the owner and see if they'd be willing to get the home qualified.
You don't have to qualify the home until after you've accepted that tenant.
Okay,
Does that make
got it.
sense?
Yep.
Okay. Liz, another question is, the real issue with the ordinance is that it requires the landlord to agree to waive their rights and comply with federal rules. How are you going to resolve that issue?
I think that's another question I would need to understand better because I'm not sure
Mhm.
what rights we're waiving.
Okay. Denise, if you can be more specific in the chat regarding your question.
Is that-
Absolutely.
Is that Denise
Oh.
Holiday?
There you
It
go.
is.
There she
Hi,
is.
Liz. How are you?
Good. Hi, Denise.
Hi. I know we've had this conversation, and I know this is a
Mhm.
big conversation for a lot of our clients, is when they agree to belong to a Section 8 program, there are special forms that have to be used. There are special rules regarding inspections and when monies are accepted. And really the biggest one is that they're required to waive some rights that they would normally have under Arizona law. One of which is they have the right to waive the right to a jury trial. And under the HUD rules, they would be forced to waive those rights by participating in the program. And you and I both know I love Section 8. I think it's a fabulous program. I'm just hesitant for any government to force someone to do business with them and give up some of their rights. And I'm wondering if you guys have thought about how to address that, because that would resolve a lot of the issues with a lot of my clients.
Thanks, Denise, for that question. I now remember because I do that we talked about this at the Tucson Association Realtors Forum, which again, thanks to all of you who are here representing Tucson Association Realtors. So I haven't reconciled that piece, Denise, and I think we can definitely talk about that. I will tell you, as I mentioned it in the last meeting when we had this conversation, is I've not had any landlords come to me since working in this program since 1996, who said, now I've lost my ability to, with the issue you just mentioned. So, how big a problem is that? In my humble estimation, it's a very minute issue, but I'm happy to try to address it if it's based on the concerns raised. And so that I would welcome the opportunity to have a broader discussion on that and bring in HUD and other legal counsel to help us work through that, so that could alleviate any concerns around losing any rights under the Arizona Landlord Tenant Act.
Okay. Liz, William Mejia asked, how is this going to affect the current residents when it comes time for recertification? Will income that wasn't considered before increase their portions?
Okay. I'm slow, Ernesto, so you're going to have to read it one more time for me.
That's all right. How is this going to affect current residents when certification comes up? Will income that was not considered before increase their portions?
So it's interesting that there's some thought that this ordinance would change how the program is operated. It does not. Where a person has income now, as those who've worked with our program before, we do an annual recertification. We look at the family's income, and the subsidy is based on the household income. So nothing changes as a result of how we do our recertifications. And so there would not be any impact or changes to the amount of subsidy unless the household's income has had a significant change. There could be a change, but that's not related to this ordinance. It's only related to the family's income or the household's income.
Okay.
And just as a follow-up, I think it's linked to the question that Denise, this follow-up question around tenants that do not meet the financial stability verification. Again, landlords have had to use multiple tools to determine qualification or criteria for tenancy. The one thing that is kind of a misnomer, is that someone who's low income does not have financial stability when they have a rental assistance program. Our participants in our program are extremely stable. And they, even though they might not meet the financial stability criteria of a landlord, the fact that they have a subsidy makes them a very stable source of for rent. So I just want to make that point is, you know, landlords currently may ask for 2 times the rent and income or 3 times the rent and income. How that is determined, again, is outside of my ability to change that process. But I would say to landlords that if someone has a rental assistance, that should be considered a very stable renter as far as ensuring that the rent is going to be maintained. So that's again, advocating for our participants in our various rental assistance programs. You can count on that rent being very regular.
Okay, thank you. Moving on. Question: would support from a faith community organization be considered a source of income that would qualify under the new ordinance? If so, it require a long-term commitment like 1 year or more. Not sure I understand completely, but it sounds like if I have support from my church, is that a source of income?
I defer back to what the source of income ordinance says as far as what is lawful and verifiable income. And if a landlord feels comfortable that based on what they've received on behalf of that that applicant meets the criteria of the ordinance, if there's any concern that it's not lawful or verifiable, then a landlord can refuse to accept that as a valid source of income. So I would always ask or encourage landlords to use their legal support, whether it's you know, a private attorney or some other source of information through maybe Arizona Multi-Housing Association, Tucson Association of Realtors. Use your resources to help sort through some of those legal questions.
Okay. At this point, there's no more questions, Liz, but there is in the chat an endorsement for the source of income ordinance. Ms. Kelly Griffith, Executive Director for the Center of Economic Integrity, writes that it's a win-win for Tucson community, ensures fairness and equity in the affordable housing market, and is sound economic policy. Okay, we have some more. Okay, there's some questions regarding individuals that are high risk health. To that person, can you again send me your questions through email? We'll try to answer those questions. They're not quite applicable to the source of income discussion. Here's another question from Denise. Liz, will the ordinance include any time frame that the city will comply with regarding the time frame to pay their portion of the assistance? Historically, it has taken up to 9 months to get rental payments.
So I will say, I just want to make sure. I apologize. Hold on. I was trying to just open that window up. So I know you said it was from Denise. Can you read it one more time? I got partial.
Will the ordinance include any time frame that the city will comply with regarding the time frame to pay the city's portion of assistance? Historically, it has taken up to 9 months to get rental assistance payments.
So I'm happy to say the 9-month period is long history. Anne mentioned that we are with, one of the things I should say, HUD requires in our contracts with our landlords that contract is only valid. We have 60 days to get that contract executed from the time we inspect. Should we, being the City of Tucson Housing Community Development Department, fail to do that, the landlord can incur fees. One of the things in my conversations with Arizona Multi-Housing Association is really coming to understand what does that, the fees and interest really, what does that mean? And so right now, with a executed contract, those payments are on average 15, but really, I always say 30 days from the time it's executed, just because of the time it takes to go through that initial W-9 process, those pieces, but it's literally not going to be more than 30 days. Often when it hits close to that 60 days, it's usually because we are waiting or having back and forth around getting the executed lease. So those are very minimal issues. Even the rent increase requests for landlords with many of our programs, that used to take a long time. We've got that process down very quickly. And one of the things we are working on in the very near future is to have a way for landlords to upload these documents electronically. So the issue of the black hole where papers get lost at Section 8 is no longer an issue. So the ordinance would not include any of those timeframes because they're already built in to the Section 8 program. The fact that the Section 8 program had times where it was up to 9 months, that housing at that time we were seriously out of compliance with our own program. And so I would just say, should a landlord see that after an executed lease and that payment isn't done, they start contacting our office. I've welcomed it. When I first got here, I had many of our large property management firms send me lists of issues until we cleared them all up. And I can tell you right now that those are very far and few between emails that we get as to payment issues. And so I can say we're super responsive with that, and that should not ever be an issue again.
Okay. Liz, if the source of income ordinance, if it is passed and it requires more staffing by HCD, how many staff will be needed to ensure that Section 8 housing vouchers will be processed quickly and efficiently?
So we are staffed up, but because of we know where the needs and the gaps, we did get a request into Mayor and Council to add Section 8 staff on the landlord support team, and that will be also it's going through the process and will likely be passed in the supplemental budget process. But we are prepared with this change in the ordinance to be able to continue to serve at a very high level. And again, I anticipate with technology and other efficiency improvements that we will continue to support our landlords with a very high performing program.
Liz, a question about the definition of source of income as it relates to income. Are Section 8 recipients taxed on this income? Do they get a 1099 or something like that? Doesn't seem like the name or description fits what we are trying to make the landlords do.
So yeah, so I would just say that we are not creating a new ordinance that has not already been tested in other communities around what a source of income. So 10 participants under the IRS guidelines, rental assistance is not something that can be taxed, at least the way the taxes are currently written. So that's a non-issue. It's just, again, the idea of under current market conditions, landlords can refuse a certain type of rental assistance if they choose not to work with a program. Under this ordinance, it would remove that ability to discriminate just solely based on that issue.
Okay. Liz, how do individual households show proof of qualifying for the assistance?
So most people, regardless of the type, landlords can ask for income verification regarding whatever program, whether it's housing choice voucher program, a program through a company called Homeek. They are providing a lot of leasing services for many of our nonprofit agencies. As an example, we would always have documents for a participant of our programs to go into a landlord to show proof of what program they're on. And it even goes as far often to show what is the parameters of the program. And you can even find out what is the portion. And we can give estimates, what the tenant portion is, what the housing authority payment is, or whatever the agency that is administering the program. So there is a way to verify that, but landlords have the ability to ask for income and to ask for those sources and to verify them.
Do landlords need to register with the Section 8 program? Maybe this, go ahead.
Yeah, good. That's a great question. All the programs are, have been, are based on the individual, not as a blanket certification. So a lot of people will use the term, oh, that's a Section 8 landlord. Actually, it's every unit goes through the paperwork for that individual, not for the program. So once the paperwork is completed, we run we do what we call rent reasonable test. It's required of us under the HUD program guidelines. And then what we do is we tell the landlord, we can honor the rent you're asking, or we can't honor the rent. Would you be willing to accept whatever dollar amount we determine is reasonable for that type of unit in that area with those amenities? And the landlord can then choose to accept that amount or to say no, and then that tenant would have to find another unit. If we accept the rent that the landlord asked for, or the landlord accepts the rent that we counter, then we schedule an inspection. Again, the inspections have been happening very quickly. And once that inspection passes, the lease can be executed the day after, and the tenant can move in, and we will get the contract between the landlord and the housing authority. One of the things we did not make clear is that the housing authority is never a party to the lease. And so the landlord would conduct business with that tenant as they would any other tenant, with or without assistance. And so that would not change under this ordinance change. The only difference is if a landlord participates with any of these rental assistance programs, there'll be a separate agreement around how that relationship and payment and terms are between the agency, the housing agency, and the landlord.
Along those same lines, Liz, does the voucher program pay the deposits and application fees, or are prospective tenants responsible for those fees?
It depends. It depends. Some programs cover those fees and some don't. And so the participants typically know if they're responsible for them or not, and they would be able to say, ask what those rent and fees are, and then be able to make those payments up front. If there is the program does cover it, then there's probably an additional form that gets completed to ensure the landlord is fully paid for those costs.
Okay. I may have missed one, but I don't see any other questions. Here's another one. All breach notices and non-renewal notices must include different language, and this requires the landlords to use 2 sets of forms. Isn't that accurate?
That is not my understanding. We've never asked a landlord to do a different set of forms. We've always accepted whatever non-payment, non-renewal notices, eviction, termination notices, whatever forms that the landlord uses, we would accept those. We have never asked a landlord to change any language in any of those forms. HUD does not require special language in different forms. Again, I've worked in 3 different municipalities. We've never asked for a different set of forms.
Okay. Liz, regarding late fees, who incurs those fees if all requirements have been met by the landlord, but payment hasn't been received?
So the housing assistance payment contracts between the housing authority or the housing agency and the landlord says, and it's a HUD template, that payments will be made at the beginning of the month. So HUD does not allow a housing agency to pay before the first of the month. So it would be the first business day of the month. 98% of our landlords are on direct deposit. And so whenever that first business day of the month is, that's when the landlord gets paid. Landlords can charge late fees to their tenants if they don't pay their portion of the rent on time. If the housing authority is negligent and does not pay their portion of the rent, which again, it happens once every blue moon, it could be that the landlord comes back to the housing authority, and I've done those in various roles, where we say, you're right, you're entitled to late fees, and often we'll negotiate those because those are not outlined. HUD does not outline what those late fees are, but when I have been very open and willing to talk about what is due to the landlord. So, and I have paid those. Fortunately, in Tucson, we haven't really done that because we have been on time, but I've been in places where I've had to do that.
Liz, if the tenant no longer qualifies for the program, is the landlord given notice?
Yes, absolutely. Again, the housing authority, a housing assistance payment contract between the landlord and the housing agency outlines what termination of the contract looks like, and it could include when a tenant no longer qualifies, which at that point the tenant is required to take over the full lease. And in those occasions, the landlord can, if the tenant refuses or is unable to pay, to exercise their rights under the Arizona Residential Landlord Tenant Act.
Okay. Liz, is there a list of criteria of what the program requires for the home? A list of appliances, whatever is required
So what I'd like to do is we'll post on this website, on our housing authority, housing community development website, what the commonly asked questions under the inspections. There's a list. And Fernando, I will ask him to make sure we get that posted. Again, the criteria is typical of what every landlord offers today. We don't have any additional requirements other than safe, decent, and sanitary, and appliances that are functional, windows and doors that open and shut, no massive holes more than 8.5 by 11 size. I joke about that, but no tripping hazards, very typical. All electrical outlets work, very just ensuring that the unit is habitable and safe.
Okay. I think there's one more question, and then we can maybe have some closing comments. Okay, a question from Ela. If we are collecting partial payment from Section 8 and part from tenant, isn't that legally considered partial payment? And if they don't pay, we cannot evict them without a partial payment agreement. Also, how much notice is the landlord given for the tenant who does not qualify?
So here's I would love to have Denise on this question with me. Denise Holiday and I and several others worked on a state statute around partial payments that said, it does not take away from a landlord to accept a housing authority payment and not be able to evict a tenant because somehow they've accepted a partial payment. A landlord under the state statute, and this happened not too long ago. Thank you, Denise. ARS 33-1371 says a landlord can evict if a tenant hasn't paid their portion and has accepted the Section 8 portion. So that was clearly something that was at odds, and we've gotten that clarified in the state statute.
Okay. So we've come to the end.
Hey,
go ahead.
Ernesto,
Yes.
Michael Short is here with Home Inc. And I'm curious, Mike, if you have any comments or questions.
He wants to be on the team.
Okay. Okay, he's good. So I just want to again thank Mike Shore, who's and Homie. They have done amazing work in many parts of Arizona and are now working in Tucson. So if you haven't worked with Michael Shore, you might want to look up a service called Threshold. And if you want to look at working with their programs, I will say they've always performed way better than most public housing authorities. So I always give them a big support for the work that they're doing. Well, thank you, Ernesto, for moderating the questions. Again, we know that there's a lot of questions around this, and please know we do orientations. And Fernando Moraga is that was highlighted. Fernando, do you want to talk about your orientation and what that covers? Should anyone want to learn more about the program?
Sure, Liz. Hello, everybody. We do a landlord briefing twice a month, every month, which goes over how the program works, what the changes have been. And it goes in the flow of the RTA when you guys submit the paperwork, how the inspections are conducted, what we're looking for, what kinds of things will fail the unit, and then goes into actual leasing and then going into contracts and covering overpayments. So we cover the full variety of what goes on in the Section 8 program and how it's changed and been benefited for a lot of the landlords. So it's a good education to refresh, even if it's been a while since you've been there. And if you're a new landlord, we definitely expect that you come to at least one. So that way we can answer all your questions and help you out with whatever that you need. We cover everything in that area.
Thank you, Fernando. One of the things I like and why Fernando's so good at his job, because he was a property manager for many years and knows the business and understands the role of our landlords. And so it makes him extremely good at communicating and helping explain many of these things. And I would really appreciate if you just take a moment to reach out to Fernando. He is extremely accessible and helpful. And I'm just really grateful for the good work. Him and his team, many of his team members are on here who do excellent work and are very, very much landlord friendly and want to work with our landlords.
Okay, I think that's it. Thank you, everyone. And do go to the site and fill out the survey. And thank you for your participation.
Thank you, everyone.